Okay, welcome back. This is Kristen at Advanced Strategy, otherwise known as Misconduct. And in the last video, we talked about some legal strategies. This is not legal advice. I do not give legal advice to anyone. Please be advised. This is for research purposes only, but we spoke about jurisdiction. We spoke about it has come to my attention that there is some ambiguous, confusing terminology being used against me. The definitions of the words and legal terms in this case are misleading. I need to request a finding of fact or ask the judge to make a judicial determination regarding the definitions of the words being used against me so we can all be on the same page before we can move forward. I may have to revoke my plea due to the deceptive terminology which has misled me into a false defense. So the notice of abatement means there are some scrivener's errors in the prosecutor's paperwork that their system requires them to fix in order for the court to have jurisdiction to hear the case or make any judgment that can be binding on real people. The court gets their jurisdiction, power, and authority from one thing and one thing only: properly pled paperwork. We talked about the charging instrument, the criminal charging instrument. We talked about the fact that it has to be perfect, and I mean perfect, or it doesn't compel any legal force. It doesn't compel jurisdiction onto the court. And jurisdiction is everything. Either they have power and authority over you or they don't. So, do they have a printout from the Secretary of State showing you as an incorporated charter? No? Then why are they spelling your name that way? Now, we also talked about challenging jurisdiction, which is the only thing you can do that doesn't grant them jurisdiction. Anything else you do grants them jurisdiction. Of course, they want you to take the plea. And then they're going to charge you with whatever you just agreed to be charged with. Now, if the court insists that it has jurisdiction for whatever reason, then go ahead and let them know that you are there to settle the matter then, not to argue about it. So you are there to oblige the court with the full credits for all the associated accounts in exchange for a discharge of the charges against the defendant. So how can you and the state win at the same time? That's what would be great. If you accept and return the presentment and exchange it, exchange your exemption for the discharge of the charges. So it's important for you to understand what you get and what they get. The state gets the credit from your exemption, and you get the discharge of the charges when you bond the case. So because everybody needs to get something out of it, or both parties are not going to want to do it. In a contract, you have to have a meeting of the minds, full disclosure, and both parties have to get something out of it. So it's important for you to understand exactly what's being exchanged so that you can better present your offer to the court as a contract that they want to enter into, which they do. Of course, they do want a discharge. They do want to get the credits from your exemption and for all of the associated accounts as well. That sounds great to them. Now, so then you cannot volunteer to defend, argue, testify, or join in the action in any way. You're just going to accept it and just discharge it from the private side. You would get a copy of the court order appointing the attorney and accept it for value. Do not dishonor the court by refusing the privilege. The public defender is for the straw man, not you. But you can accept his services and instruct him on how he will handle the case. You could do this because you are the creditor through your acceptance. You are in honor, and so is everyone else. Prepare a letter of instruction to be mailed to the appointed attorney. It is a contract. Let him know that you have an intervening interest in the subject matter of the case. Let him know that your property rights, which your freedom is your property. Let him know your property rights may not be protected by the existing parties. Let him know you accepted the attorney appointment offer and you return it to him. And you request that he put his bar card away during this case. Doesn't mean he's going to do it, but you can request it. You're going to request him to act as counsel instead of acting as attorney. You're going to let him know that there is no controversy over the facts and that he cannot start or join an argument. He's not authorized to defend the defendant. You are asking him to read your statement in open court and file it with the clerk. You already have an agreement of the parties. You are asking him to check the clerk's file for a bond and bond the charges. You are not disputing the facts. You want the prosecuting attorney to write the check to close the account. You will accept the prosecuting attorney's bond to bond the charges if he would rather do it that way. You can let him know that you will start bankruptcy proceeding if necessary to get your remedy. Let him know that you want settlement and closure, and that you may require the defense attorney to file a notice of appearance in the case. Prepare the bond to bond the case. This bond will now balance the books for the court. Do not notarize it. Now, if you're in jail, it's very difficult for you to, get the supplies to write these letters, and certainly to access a notary is going to be extremely difficult. However, what you can do instead of having your document notarized is sign it in front of two witnesses and have those two witnesses sign your document as well. Okay? So you can do that, and you can certainly have someone act as an intermediary to send letters and be able to receive letters for you. To have them act as a notary just with the two signatures instead of the stamp. Okay? If there is no public defender that you're using for your case, then enter your certificate of non-response into evidence and request a judicial review of your administrative process. If the judge does not dismiss the charges by discharging the bond, you can remove the case into another court with an amended complaint for judicial review, possibly from a justice court to a county court, from county court to federal court, or from criminal to civil. It can be the same judge and same filing fees. You're not asking for a default judgment. He's already in default. You want a judgment in estoppel. The default should be already certified by your certificate of non-response. And then don't interfere. Let the lawyers talk. If you do any of the following, you lose. If you testify, argue, call witnesses, file an answer. If you explain your private process to anyone, don't explain it. It's private. So don't explain it to anyone. It's not a public information. Don't dishonor the judge, don't dishonor the prosecutor, and definitely don't dishonor your own lawyer by interrupting him. Let him know that he will snivel about it, and he will act like he's not going to do it, but he will file the letter of instructions into the case. On the court date, have a cue card for him stating the things that you see on the screen. There is no controversy. You want settlement and closure. You've accepted the judge's oath and have a contract with him. You've bonded the case. Let's look at these documents now. The presentment is like a check. It is sent to you with a request for some kind of payment. If you endorse it and return it, they know you have approved the use of your credit. They can then use your endorsement, since they did not send a check made out to the straw man, to settle the debt, account, the case number, with an offsetting credit. They just need your authorizing signature to get the credit to enter on the books. Remember, there is no money. This is from Creditors and Their Bonds, a quick look into the administration process in public courts. So this doesn't come from me. This is information that I learned about from Yusuf L. Recap. Private administrative process. 1. The notary sent your notice of acceptance with your acceptance and return. You could have a friend act that part for you, either someone inside or outside. 2. The notary sent a notice of non-response or notice of breach. Right. So when you return the presentment, you return the charging instrument to the prosecutor and let him know to settle it, settle the matter. And when he doesn't, and let him know that you show the account balance as 0 and ask him to let you know about that. And if he doesn't hit you back and let you know, then send him the notice of non-response, which is a notice of default. The non-response or certificate of breach will establish, the certificate will establish that you accepted and returned and exchanged your exemption for a discharge, that your acceptance was received and accepted by the respondent, the prosecutor, twice, if possible, that the respondent refused to respond or comply with your request. Your request was to let you know that it was a 0 balance. That there is an agreement of the parties. Since he didn't respond, that means he agrees. That the respondent has no commercial energy to pursue the collection, and that you have all the commercial energy regarding the subject matter, that you are in honor and that the respondent is in dishonor. And you should also let him know that if he continues to try to collect on that debt, that you will have the right to collect $5,000 from him if he does so, and that you can get your money. It's always time to let him know your fee schedule for things. Number 4, remedy. Accept and return the court presentment. If there is an assessed value on the presentment, use accepted for assessed value and returned in exchange for closure and settlement of this accounting. Date, signature, EIN, which is your social without the dashes. And that's your private exemption number. If there is no assessed value on the presentment, use accepted for value and returned in exchange for closure and settlement of this accounting. And I would like to say, and associated accounts, because they do exist. And I think they'll be happy to know that you're willing to pay them all, or discharge them all rather, and let them get all the credits they need. Attach an asset, an authorization for the state to use your credit. A bill of exchange is one of the instruments you can use, an international bill of exchange, to authorize the use of your credit. It is a writing, a bill, that you are giving the claimant in exchange for the discharge of the claim debt charges. It settles the immediate charge. It needs the name of the person who is to receive the credits, the name of the public creditor, who is the Secretary of the Treasury, Janet Yellen, the name of the public pass-through, your straw man, your name in all capital letters. It is a trust. Instructions, an instruction number, your name, the private creditor, a proper noun, your exemption number, creditor ID number, that's the social without dashes, your signature, this is the endorsement. This is an example of the letter to the counselor. Dear Mrs. Jones, please take note that I am claiming an interest relating to the property which is the subject of this action in rem. That means admiralty. I am so situated that the disposition of the action may as practical matter impair or impede my ability to protect that interest, which is not adequately represented by existing parties. You need to put this in your own words, brothers and sisters. Just say it straight, the way you feel it. Make it your own, and you have it say what you want it to say. But just to give you an idea, this is a very good book. It's only 47 pages long. Go get it. Go read it off of the Internet Archive. When Yusuf El tells you you should go read something, you should go read every single thing he recommends to you. I accept the kind order of the court to appoint you attorney for the defendant. I accept this offer for value, and I'm returning it with this notice to you. I now request that you escrow your bar certificate during the course of this case and serve as my counsel in the following manner and only in the following manner. There is no controversy in this matter. I do not want you to argue any facts or public issues as they apply to the defendant. You are not authorized to foster an argument or to join an argument on my behalf or on behalf of the defendant. You may not defend the defendant. For you to stay in honor, I want you to enter the notice into the record by filing it with the clerk of the court and by reading it into the record in open court. This is notice that I have accepted for value and returned all public offers associated with this matter, and notice that I have made every effort to reach settlement through exchange of my exemption for adjustment and set-off of the public charges against the defendant. Now, go read HJR 192. It tells you right there, yes, the government is obligated to so-called pay your debts dollar for dollar because you cannot pay them anymore. Since 1933, they took the gold. Okay, so they had to give us something in return, and that's what they gave us. So that's what those accounts are for, situations like this. It's exactly what they're for. Let's stop playing games in court. Ask the judge to take mandatory judicial notice of the private agreement that has been reached through offer and acceptance. Basically, they didn't answer you back, so they agreed to it. I want you to get a copy of the bond that bonds the charges in this matter. If there is no bond in the file, then I will provide my bonds instead. Who can be mad at you? You want to take responsibility and settle the matter. No one can be mad at you. I want you to request an appearance bond at no cost to me so I can be released on my own recognizance. When the bond has been issued, I will enter a plea of guilty to the facts for the defendant. I will not dispute any of the facts in this matter, but I do not agree to be held personally liable with no protection. If you're in jail, somehow you agreed to be the trustee, and they have usurped you out of your rightful position as executor and creditor through ignorance. But now that you understand some things, these are some strategies that you can consider doing more research about. If for some reason my request for an appearance bond is dishonored, I want you to give notice of my intent to accept the prosecutor's bond for value and to use it to bond the charges. Use his bond as surety. His signature is the only one on record as a responsible party. Bam! He's on the hook, brothers and sisters. Actually and truly and financially so. That's why attorneys are instructed to bring their checkbook to court. He is on the line for it financially. So he's not in a good position. He will dismiss the case every time. If necessary, I also want you to give notice of my intent to accept John Brown's bond for value and to use it to charge us Chapter 7 involuntary liquidation and start discovery under 11 U.S.C. 1126B. If the dishonor is not cured within 72 hours, I want you to file the bankruptcy petition in the federal bankruptcy court naming the defendant as the debtor and John Brown, the prosecutor, as a delinquent creditor, along with the others who may have dishonored me. You are authorized to distribute B10 proof of claim forms to the dishonoring parties, should there be any at the next hearing. This bankruptcy discovery process will locate my remedy and release it to me through liquidation of the delinquent creditor's assets. In the event that you, as my fiduciary, dishonor me by not following my instructions, I request that you file a mandatory judicial notice of your refusal with the court and file a written appearance in this case. Thank you for your understanding and cooperation. This is a sample of a letter to the judge. Dear Judge, please take notice that I have accepted the presentment made by so-and-so, the prosecuting attorney, to the straw man for assess value and returned it to the presenter in exchange for closure and settlement of case number so-and-so. I have exchanged my exemption for a discharge of the charges. I enclosed an authorization for him to use my credit to discharge all court charges that may apply. The instructions and a statement of account were attached, showing that you show it zero balance. The Treasury has also been notified that I'm using my credit for this purpose. I request an appearance bond at no cost to me, so I can enter a plea for the defendant. I do not dispute any of the facts in the charging instrument. Based upon the issuance of the appearance bond and the absence of an assessment and findings of fact and conclusions of law, in other words, in the absence of any argument, I will enter a plea for the defendant, exchanging my exemption for full settlement of the account, both civil and criminal, and all the associated accounts. I have requested that I be notified through the notary or through your third party, you can call them a third party, named above with the place, date, and time I should appear to receive the appearance bond. I expect that will also be when I will enter the plea for the defendant into the record. The opposing parties have previously reached an agreement on the issues in the complaint. There is no controversy. A copy of the relevant certificate is attached. I want settlement and closure of this account immediately. This is an overview of the creditor process. Accept for value and return the court presentment to the signing attorney. Attach a credit authorization with instructions for the attorney to use this to settle the court accounting. Send a letter of credit to the Treasury. Get a certified copy of the judge's oath and accept it for value. I don't know where you can get that. But you can and should at least state it verbally. Let the judge know that you accept his oath. That's good enough. Give notice of your acceptance by a private mailing to the man or woman doing business as a judge. File a notice of acceptance on the public side. Get a copy of the court order appointing the attorney and accept it for value. Prepare a letter of instruction to be mailed to the defense attorney and to request bond. Check the clerk's file for a bond. Prepare your bond to bond the case. Remove the case to another court if necessary for judicial review of your administrative process. So just remember now, so what they get is they get the credits through your exemption. The state gets them. You get a discharge of the charges. So when they get the credits, it's like money. It is an asset on their books to balance out their double entry bookkeeping method. You gave them credits for all the associated accounts. You just paid them. And guess what? That's what they wanted all along. Judges are bankers. They have access to the accounts of commerce. That's why they negotiate privately with the lawyers to negotiate settlement. So let's stop playing games in court. If man is the hand, then when the executor shows up on the scene and pops his head up and says, "I'm here," then boom, the party is over for the trustees. Up until then, the trustees are running wild, doing whatever they want. Now that the executor is here, bam, the trustees will receive instruction from the executor. The executor tells his trustees what to do. It's simple. Be nice about it. Judge, I authorize you to act as my trustee and settle the matter. I'm not here to argue. I want a discharge of the charges. This court has received my private form of credit authorization payment, which is private, so I will not explain it here to anyone. I have sent the credit authorization to the judge in private. Judge, were you able to receive my private settlement offer in exchange for the discharge? Just remember that you got to stay calm. And it's not personal, it's just business. Who can be mad at you? The judge certainly cannot be mad. He's getting paid. Either way, he's getting paid. And you're there to settle the matter. You're taking responsibility. This is what creditors do. The creditors go around cleaning up all the messes that the debtors make. Okay? So it's just everyday business for the creditor to go around and just, okay, fine, I accept the charges. I will pay them. Let's just settle the matter and be done with it. And let them know that you don't agree to be the surety, you don't agree to be the trustee, that's what got you in there in the first place. That and the deceptive terminology about your activities at the time. So I hope this is helpful to you, and I hope that you're able to get access to some supplies so that you can write your letters. And just remember to practice and meditate on your questions. If A, then B, then C. Okay? If A is like B and B is like C, then A is like C. You have to use logic and verbally box the judge into a corner and stand on your square. I love you guys because you care about the truth and you care about getting to the bottom of a matter and understanding it. And if you can stay calm in the midst of chaos, you're going to be all right. Take care and stay strong.